She drafted the contract, signed it, then pretended it never existed. She signed the contract, she cashed the check. Then she told the school she'd never agreed to any of it. The plaintiff had spent 11 years on the Maplewood Ridge Homeowners Association board, the last 4 as its treasurer. By all accounts, she was meticulous, the kind of person who color-coded meeting minutes and sent certified letters when a neighbor's grass grew half an inch too tall. When the board voted to rent the HOA's community pavilion to a nearby elementary school for their end-of-year field day celebration, she was the one who drafted the rental agreement herself. 14 pages. Notarized, $3,400 due upon signing, with a $200 damage deposit held in escrow. The school's principal signed it on a Tuesday afternoon in early April. By Thursday, the check had cleared. 6 weeks later, the plaintiff filed suit against the school district for $47,500, claiming the event had caused structural damage to the pavilion's wooden deck, violated noise ordinances, and that the original contract had been signed under what she described as undue pressure from the board's majority. She wanted the damage deposit back, the rental fee refunded, and an additional $40,900 in claimed repair costs and emotional distress. The school district's attorney arrived to court with a thick folder and a very calm expression. The plaintiff took the stand and described a chaotic scene. 200 children on a deck she claimed was rated for 90. She presented photos of splintered boards, a cracked support beam, and a gutter pulled partially from the fascia. She testified she had raised concerns before the event and been overruled. She said she had signed the contract only because she felt coerced by the other board members. Her voice cracked when she described driving past the pavilion the morning after and seeing the damage. She was, she said, heartbroken. This pavilion had been her community's gathering place for decades. The school's principal was equally compelling. She testified that every capacity and noise condition had been strictly observed. The school had hired a licensed event coordinator, brought in portable restrooms to reduce foot traffic on the structure, and had the event wrapped up by 4:15 p.m., 45 minutes before the contract's required end time. She had documentation for all of it. She described the plaintiff's lawsuit as a personal vendetta dressed up as legal principal, and then stopped herself, visibly choosing not to elaborate. That restraint was almost costly. Almost. The twist came from the plaintiff's own phone. During discovery, the school district's legal team had subpoenaed communications related to the event. What they found was a text thread between the plaintiff and one other HOA board member, sent 3 days before the field day took place. In it, the plaintiff wrote, and these are her words entered into evidence: "I don't care if those kids do everything right. I'm going to find something wrong with that deck after they leave. The school never should have been allowed in here, and I'm going to make sure this never happens again." The response from the other board member: "You're going to get us sued." Her reply: "No, I'm going to do the suing." The plaintiff's attorney requested a recess. The judge denied it. The photographs of the damaged deck were then cross-referenced with maintenance records the district had quietly obtained from the HOA's own filing system, records the plaintiff, as treasurer, had authored. The cracked support beam had been documented in a pre-existing inspection report 14 months earlier. The splintered boards appeared in a photo taken the previous November. The damage existed before a single child set foot on the property. The judge didn't deliberate long. She ruled in favor of the school district on all counts. The $3,400 rental fee was deemed non-refundable. The $1,200 deposit was ordered returned to the school, not retained by the HOA. The plaintiff's $47,500 claim was dismissed entirely. Additionally, the judge found the suit to have been filed in bad faith and ordered the plaintiff to cover the school district's legal fees. $11,000 said that all I saw in $200. The total reversal came to $12,400 out of the plaintiff's pocket. She resigned from the HOA board the following month. The other board members did not ask her to reconsider. The pavilion, for what it's worth, was repaired the following spring using HOA reserve funds, the same funds the plaintiff had managed for 4 years. The school held their field day elsewhere that year. They haven't been back. The principal, when asked about the outcome, said only that she hoped the children never found out what had almost been done in response to their field day, which leaves the question worth sitting with. When someone in a position of institutional trust decides to weaponize that trust against people who did nothing wrong, and the only thing that stops them is their own words. How many times does it happen when there are no text messages to find?